Welcome to Lawline. In honor of Law Day, we have come to Albany to visit the highest court in New York State, the Court of Appeals. Right now, I'm sitting at the bench where the 7 judges hear the attorneys pleading their clients' cases. We'll be meeting with Chief Judge Saul Wackler and the associate judges. We'll learn how the court works and discuss some of the landmark decisions. Let's go meet with the Chief Judge. Thank you, Judge Wackler, for having us here in this magnificent courtroom in the Court of Appeals.
It's a pleasure to have you here, Alan.
Judge, can you tell our audience, what is a typical day in the life of the Court of Appeals like?
Well, the judges on our court are very hard-working judges. They get here about 7 o'clock in the morning every day. We go into conference at about 10. Not about 10, exactly at 10. And we stay in conference till 12:30, have lunch, and then take the bench. We take the bench at 2 o'clock in the afternoon, except on Fridays when we take the bench at 1 in the afternoon. We get off the bench about 5:30. We all go to dinner together at 6. At about 7:30, we're back from dinner, back in our chambers, and we stay there till about 11:30 in the evening.
Now, how does a case get to the Court of Appeals?
Well, this is the court of last resort. In most cases, this is called the Supreme Court of the state. It is the Supreme Court of the state because, as I say, it is the last or the highest appellate court within the state. After this court, you can only go to the United States Supreme Court, and then not in every instance. So for most cases, this is the end of the line. A case starts in the trial court, and then you have the intermediate appellate court, which handles all the appeals from the trial court, and then on permission, certain cases are allowed to our court, usually about 300 or 400 a year.
Well, who comes here? Do you have the litigants here? Do you take testimony here?
No, only the lawyers come here. We read the briefs. We're bound by the record of the trial below, that is the trial that was conducted in the trial court, the evidence and so forth. We don't find facts here. We just apply the law, so that we take the record as it's presented to us from the trial court, and the attorneys, one representing the appellant, that is the side which lost in the court below, seeking to overturn what was done below, and the respondent, which is the winner in the court below, seeking to sustain the victory. And the two of them argue the case. The case is argued before the 7 judges of this court, and then the 7 judges parcel out the cases. Each one reports on a separate case in conference, and then ultimately we vote on it. If 4 judges vote a particular way, either to affirm the court below or to reverse the court below, that becomes the decision of this court.
Now, I was watching yesterday in the courtroom that all the judges were asking questions. Is each judge assigned a particular case?
Yes, each judge is assigned a case, but only after the oral argument, so that when the cases are being argued, no judge knows what case he or she will draw. When all the arguments are concluded, we retire to the robing room and we take a card. Each card has the case name on it, and we pass the cards out, and then we draw the cards in order of seniority. And that's the first time we know what case it is that we will be responsible for.
When you say responsible for, you mean writing the decision?
Well, it all depends. We're responsible for reporting that case during the conference. It's almost like show and tell. We take that case and we say, we believe this should be affirmed. We explain our reasons for it, and then we go around in the order of seniority. We go around the table, and we see how many judges agree with the position advanced or how many disagree. If 3 other judges agree with you, then you have the court. Then you have a majority of the court, and you write the opinion. If another judge disagrees with you and 3 judges agree, 3 or more agree with that judge, then that judge will write the opinion and you'll write the dissent, or else you might join in the opinion. It's a dynamic.
What happens if you have 4 judges on one side, 3 on the other? One judge wants to convince one of the judges in the majority.
Oh, yes, you try to convince all the time. Right up until the moment that case is handed down as a written opinion, you try to persuade one side or the other to join the majority. You want to change the result. And that's where you have the constant give and take and debate and almost adversarial system within the court itself. It's a very healthy process.
Now, there are 7 judges. If one judge was to be sick or for whatever reason excuse him or herself from a case, then you have 6. Do you ever have ties?
Oh yes, we've had that before, and we'd have 3-3, and if there is absolutely no way of breaking the deadlock, no one judge will side with one side or the other, so you have a 3-3 stalemate. We vouch in another judge. We usually take a judge from the appellate division, bring that judge in, and then schedule the case for re-argument. The case is then argued all over again, and a panel of 7 then re-decides that case.
The typical case, how many times is it conferenced?
The typical case is conferenced perhaps twice after the argument, and then when the writing comes down, the writing might be on the table 3 or 4 different conferences where various aspects are in the collegial process worked on, so that ultimately the writing will represent the consensus of those who have joined in the writing.
Now, which cases get to be heard at the Court of Appeals level?
Well, in the criminal side, the criminal cases, any one judge in our court or a judge in the appellate division can grant leave to that appellant to come to our court. Either the defendant on one side or the prosecutor on the other side, depending who wins below. In the civil side, on the civil cases, that is the non-criminal cases, it takes 2 judges on our court after reading a report on a motion for leave to appeal. It takes 2 judges on our court to grant leave, or 2 judges in the appellate division to grant leave.
Your court, how do you categorize it? As liberal, conservative?
It can't, it defies that kind of categorization, Alan, because each case is taken as a separate case. The law is applied. Commentators have been trying for some time to determine whether we are a liberal court or a conservative court. We were marked recently as a pragmatic court, a court which does not fall into any one category, but which really decides the cases appropriately and properly based on the precedents.
How does one become a judge of the Court of Appeals? I
was a trial judge, and then I ran for the Court of Appeals. All the other judges on the court were appointed, but then I was elected, and then the Constitution was changed, and we became an appointed court. So all of them were appointed by Governor Cuomo. That was their entry onto the court. My entry on the court was the election process. It was a statewide election, and I became chief judge by virtue of appointment by Judge Cuomo. So every one of our judges right now sits under appointment by Governor Cuomo.
Can Governor Cuomo appoint anyone he wants to the court?
No. What they do is, when the term is up, and our term is for 14 years, the Judicial Nominating Commission submits names. Many people apply. They go through a screening process, and on the merit screening process, certain names are submitted to the governor, between 3 and 7 names, and the governor must select one person from that list.
Well, if the governor doesn't like those names on the list, what can he do?
He has nothing to, he can't do anything. He has to appoint from that list. That way, it prevents the governor from just randomly selecting anyone whom he might please. He's restricted to a group, and we know that that group is found to be highly qualified by a nonpartisan screening panel, which interviews and very carefully selects.
And a sitting judge of the Court of Appeals, if his term is up after 14 years, does he have to go through this committee as well?
Yes, he does, or she does. Yes, the name is resubmitted and the process is repeated. I might say that, and I know this is somewhat self-serving, that Governor Cuomo has done an excellent job, both in putting the first woman to ever serve on our court, that's Judge Kaye, and the first black judge to ever serve for a full term on our court, that's Judge Alexander. He has been completely nonpartisan in the selection process. Coincidentally, 3 members of our court are enrolled Republicans, 3 enrolled Democrats, and 1 registered in neither party. And there's a geographical balance. We have upstaters and we have downstaters, and I think really excellent jurists.
Now, I know you hold 2 positions. One is Chief Judge of the State of New York, and the other is Chief Judge of the Court of Appeals.
Yes.
What are your roles in these 2 positions?
Well, as Chief Judge of the Court of Appeals, I preside over this court. I'm the judge who is assigned the task of leading the conference. I have no more votes than any other judge on the court. I'm also responsible for this building. Statutorily, and this is an anachronism really, the statute says that the Chief Judge of the state or the Chief Judge of the Court of Appeals shall be in charge of the Court of Appeals Hall. So this is my home, both figuratively and literally. The other obligation I have as Chief Judge of the state, and that's a separate constitutional title, is the Chief Administrator of the court system in the state of New York. That is the 13,000 non-judicial personnel, the 3,000 judges, and the 270 court facilities all come within the jurisdiction of the third branch of government, the judicial branch. And again, constitutionally and legislatively, I'm in charge of that. I, in turn, am able to appoint a chief administrator of the courts. In the New York State, it's Matt Crossan, and Matt Crossan is the chief administrator to whom many of these powers are delegated. But ultimately, the responsibility is with the Chief Judge of the state.
Well, if a judge in Queens has a problem in his particular part, does it end up at your desk?
What usually happens is in Queens, he would go to Al Lerner, who is the Chief Administrative Judge of Queens County. Al Lerner, in turn, will work through Milton Williams, who's the Chief Administrator or Deputy Chief Administrator for the City of New York. He, in turn, would go to Matt Crossan, who is the Chief Administrator for the entire state, and then Matt and I would discuss the problem.
Okay. Now, what if they want more courtrooms? What if there's not enough courtrooms? What happens then?
Well, every year we prepare a State of the Judiciary message where we outline the needs for the court system. We present that to the legislature. We also present a budget every year to budget for the needs of the court. This budget is also submitted to the legislature. And then the battle begins. And we fight for all these things which we desperately need. As far as court facilities are concerned, the facilities themselves are the responsibility of the municipalities, the counties and the cities where those facilities exist, where those courthouses exist. So we have to deal with them as far as that is concerned.
You use the term battle. Is the battle being won or lost now?
Well, there are some victories and some losses. Right now, we're having the battle of our life because all the states in the Northeast, as you know, are facing an enormous budget crunch. We've submitted a budget of some $985 million. We expect to be cut. But the burden that we have now in the court system is greater than has ever been faced in the history of the state of New York, mainly because of the drug problem, where the numbers are staggering. We resolve some 3.5 million cases a year, civil and criminal, in our state court system. It is the largest unified court system in the United States of America.
How does that compare to the federal system?
Well, we handle in 1 year 10 times the cases which are handled in all of the federal courts in all of the 50 states. And as far as the drug cases are concerned, and we've heard that the president is saying that he wants to increase the federal judicial complement because of the enormous amount of drug cases coming into the federal courts, the comparison is this. In 1 day, we handle more drug cases in New York State than the entire federal system in all 50 states handles in a year.
Judge Wackler, if you had a crystal ball, could you tell us what would happen to the court system if you didn't get the money that you need?
We might have to do what the state of Vermont did when they were cut back. They had to close down their civil courts. Now, we could not think of that, but we might have to close down certain parts because we cannot operate without the judges and the non-judicial personnel. We have been asking for 3 years for additional judges, and we've received none. In the criminal court now in the city of New York, we have 1,000 cases a day coming into that court. And we have some 80 judges handling them. Each judge can spend about 4 minutes on each case, which means that you can't try any cases. In the criminal court of the city of New York, all you can do is process pleas. Now, the citizens of this state deserve better than that.
Now, just to change the topic a little, you mentioned you're also chief of this particular courthouse.
That's right.
And you've graciously invited us into your home.
That's correct.
Now, I noticed the chairs that we're sitting on. Can you describe them to us?
Well, these are the Ram's Head chairs. These are extremely precious and valuable, priceless, literally priceless. And we're not, we don't have them all over the court room, but we have several of them, and they're studied by people who know fine woodwork. They come from all over the country to look at the Court of Appeals Ram's Head chairs. As you will note in this courtroom, we have probably some of the most magnificent woodwork that you'll see anywhere in the country, or in the world for that matter. Each of the panels, for example, around the frames of the associate judges, which are the smaller pictures on the bottom row. The former chief judges are portrayed. Their portraits are on the top row, the larger portraits, and the associate judges, the former associate judges, are the smaller portraits. But each frame around each associate judge is individually hand-carved, and no two have the same design, similar to the panels on the bench. Each one individually done, each one unique.
Now, I saw on the bench, does each judge have their particular chair that they sit in?
Oh, yes, and it's all in order of seniority. We do everything by seniority in the Court of Appeals. That's been the tradition for 200 years. We walk out in order of seniority. We walk back into the robing room in order of seniority. The robing room has, in order of seniority, each locker where our robes are stored. We sit around the conference table in order of seniority, and on the bench. The chief judge traditionally sits in the center chair. And then on the chief judge's right is the senior associate judge, Judge Simons. On the left is the next associate in order of seniority, Judge Kay. And then it goes back and forth, rotating from one side to the other, down to the junior judge, Judge Bellicosa.
Now, Judge, before the interview, I snuck behind the bench and I saw some spittoons there.
Oh, yes. Those are the brass spittoons which have been there again for 200 years. They're not used today. At least I don't think so. But those are the same brass spittoons on rubber mats.
But somehow I pictured if one of the judges didn't like an argument, he would turn to a spittoon from time to time. And
that's right, and probably if he hit on target, you were in better shape than if he missed.
I'm going to ask you about the clock right after this break. I'm Alan Schnorman, your host. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is, there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors, or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
The party's over. All over, one for the road. All over for the 25,000 Americans who die each year as the result of drivers who drink. Drivers who don't realize how little it takes to turn the average social drinker into a tragedy. So please, take this advice from this station and the members of the New York State Bar Association. When in doubt, don't start out.
Hello, you're watching Lawline. I'm Alan Schnorman. We're at the Court of Appeals in our state capital, Albany. We're speaking with Chief Judge Saul Wackler. Judge Wackler, right before the break, I asked you to tell us about the clock.
Well, that clock is one of the masterpieces of wood carving. When I first came on the court, the clock was on loan to a museum out in New Mexico, and it had been traveling all over the country on exhibit in various places. And one of the first things I did when I became chief judge was to say that clock is to remain here and never to leave these premises. If anyone wants to see it, they can come here to see it.
And what other things about the particular courtroom?
Well, let me just take you on a verbal tour, if I might, Alan.
Please.
When you walk into the courthouse, you come into the beautiful rotunda where you'll see columns of granite that were cut in Sing Sing prison by prisoners over 100 years ago. And then it was taken up the Hudson River by barge, and then up State Street by ox cart and placed in this building. This was the old State House originally. And then the courtroom, which was over in the old Capitol, was taken over and put in the State House. This fireplace, for example, that's behind us, and all this woodwork was all taken piece by piece from the old Capitol and placed in this courthouse. When you first come in the courtroom, you'll see a statue of, and the only statue in the courtroom, of Robert Livingston, who was the first Law Chancellor of the state of New York. Robert Livingston wrote the Declaration of Independence with Thomas Jefferson. And while he was working on it, his former classmate and graduate and former law partner, John Jay, summoned him back to New York to help him work on the New York State Constitution. They were 29 years old at the time. And he came back from Philadelphia and started working with John Jay, whose portrait hangs above where I sit on the bench. And these two young men, joined by Gouverneur Morris, who was a delegate to the Constitutional Convention from Philadelphia, but at that time was a New Yorker, these three young men started working on the New York State Constitution. And they were chased by the British from New York City to White Plains, ultimately to Kingston, New York, where the Constitution was finished. And this is 10 years before the federal Constitution. You see, if we had gained our independence, which we ultimately did, each state had to have some governing body. And the Constitution was finally finished in Kingston. The people in Kingston are very proud that this was the first seat of the state government. The only reason it was because White Plains and New York City had been captured by the British. And then Kingston was burned down, and they ultimately went to Poughkeepsie to ratify the United States Constitution. But after the state was formed, Robert Livingston became the first Lord Chancellor. He was the one who swore in George Washington as the first President of the United States. And in his right hand, when you look at the statue, you'll see a roll of parchment. That's the Louisiana Purchase, which he negotiated on behalf of the United States. And John Jay, of course, was the first Chief Justice of the state of New York, and 10 years later became the first Chief Justice of the United States. And so you see, we've had a rich history. By the way, Robert Livingston was from Claremont, New York, and took the first trip on the steamboat up the Hudson River, which was called the Claremont, named after his hometown. Took him 29 hours to come from New York City to Albany by steamboat.
Sometimes in heavy traffic, it could take almost as long.
That's right. As you look around the portraits, you'll see distinguished jurists who have graced the bench of this court. One, you'll see Cardoza, Benjamin Cardoza, who was considered one of the patron saints of the Court of Appeals. Served as an associate judge on this court, then as chief judge for some 8 years, and then went on to Washington to become a member of the United States Supreme Court. In his portrait, you'll see he's standing behind a desk. That desk is now in the chambers which I occupy, because I occupy the chief judge's chambers. And of course, it's a great honor. I remember when I was sworn in as chief judge, and I went in and I saw my desk and I said, just think of it, that will be my desk, the desk used by Benjamin Cardoza. And someone said, yes, but remember, in 50 years from today, it will still be Benjamin Cardoza's desk. And that's a reminder, of course, not only of our mortality, but of course of the greatness of that man. So we are surrounded by history in this chamber, and there's not a member on this court who doesn't have a sense of that history every time we take the bench.
Well, it's a magnificent room. What about the other rooms of the court building?
Well, of course, each judge has his or her chambers in this courthouse. Each chamber is beautifully furnished, some in the original furniture, as is mine, which has been here for dozens, if not hundreds of years. And it's a very unique building. It's a gem. When they first built the mall over here, across the street in Albany, they wanted to build a Court of Appeals hall in the mall, in the governmental complex. And our predecessors said, no, absolutely not. We are a separate branch of government. We want a separate courthouse, and we want to retain this gem of a building, which we have done.
When I walked in, I saw the ceiling of the rotunda. Can you tell us about that?
Yes, well, that is the signs of the zodiac. We were teased about that because it's on a field of blue with stars, and you know, the original Star Chamber got its name because there was a canopy of stars on that. So that's why they imposed the zodiac signs, so no one would call this a Star Chamber, which of course was an example of medieval injustice. But the three columns on each floor are in the traditional Greek style, Ionic, Doric, and Corinthian. So each one is unique. These columns, which, as I say, were carved by the prisoners in Sing Sing.
Overall, how many years have you been on the bench now?
This is my 17th year on this court.
I'm sure there are certain cases that come to mind.
Oh, so many. You know, we've been responsible for the Grand Central Terminal standing and the Sunday Blue laws falling, and we said that Taiwan could not come to the Olympics. We've said that a husband could be found guilty of rape of his wife. We have, I could go on all day enumerating the cases. Most recently, just last week, we had an interesting juxtaposition. On one day, we had a case affecting the homeless of the city of New York, involving 10,000 people and millions of dollars. The very next day, we had the America's Cup decision, which we have to render. At that time, I observed that it seemed rather strange that the finish line of the America's Cup race should be here on Eagle Street in Albany. But because the deed of trust, which concerned the America's Cup, was a New York trust, a New York deed of trust, our court has to interpret whether when America sailed a catamaran against New Zealand's single-hulled schooner, whether that catamaran could be deemed the winner or not. So that's a case which we will ultimately decide.
Judge Wackler, can you tell us, on a personal level, what it's like being Chief Judge of the state of New York?
Well, it's a great feeling. It's an awesome responsibility. It's humbling in every sense of the word, because you can never feel yourself worthy of the responsibility on either side, either on the Chief Judge of the state side, because of the administrative responsibilities, and because you know that the system of justice depends in great measure on things which you can influence. So that's, again, a tremendous responsibility. And then on the adjudicative side, the Court of Appeals being the court of last resort, knowing that the person who's coming before your court, this might be his or her last opportunity, either at freedom or to retain his or her fortune. And this is the end of it. And so you recognize that each case, we're not dealing with hypotheticals or moot courts. Each case involves real people, real stories, and it's something that you have to understand as far as the responsibility. And each judge on our court is very mindful of that. And that's why, again, the responsibility is great and the burden is great.
Judge Wackler, are there tensions that develop between the judges because of the nature of the cases?
Constantly, because of very strongly held beliefs by each judge. And you try to harmonize those views and you try to reach consensus, because you're not dealing with a monolith here. You're dealing with 7 individuals, each of whom have their own ideas and their own views on cases and on the law. So you try to harmonize those views, you try to build consensus, and you try to, at the same time, to maintain the collegiality of the court, which is very, very important. And we've been blessed in that respect, because we have, I don't want to heap too much praise on my colleagues, because again, it sounds somewhat self-serving, but they are remarkable judges, and I think remarkable individuals, and we relate very well to one another. And this is very important. Not every court of last resort in this country, I can tell you, shares that great privilege.
Judge Wackler, why is it that one court could decide a case one way, and then 15 years later, another court decides the case totally different?
Well, our court, which tries to harmonize the views, that's why one of the reasons we sit here is so there's one court, as our Constitution says, to try to rationalize the diverse opinions of 2 different courts below. Our court renders the decision. Now, that is a precedent. That is the law of our state as it relates to that case and that set of facts. Now, it could be that 20 years later, because of a change in the mores of the people, because of a change of a generation, because what was considered, for example, obscene 20 years ago is no longer obscene, that the court then changes that precedent. But it's a slow and gradual process. We had a case argued yesterday. I wrote a vigorous dissent against the law that was established the first time. Now a lawyer argues a case before us and says this is an opportunity to change that law. But it was only 6 years ago. So even though I think the law was a bad one, I think the rule of law that we articulated was wrong, and I said so at the time. I am now bound by that. That is precedent. And I will defend with every ounce in my soul and body to preserve that rule of law, despite the fact that I think it's wrong. Only because that is the rule, and we have to have some stability in the law. And that's what our common law process is all about.
We have to take a break now, but I'd like to go into, after the break, the public mood and what effect it has on the court and the decisions. You're watching Lawline. We're here in Albany with Chief Judge Saul Wackler. Stay with us.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
My father taught me to steal and to pitch. Today I struck out 7 and stole home. I think Dad would have been proud. Coach was. He said he wished Dad had taken as good care of himself as he did of me and Billy. Billy won't talk about it, and Mom can't stop crying. I don't know what it's like to have a heart attack, except I can see it hurts. It hurts bad.
You can help prevent heart disease. We can tell you how.
Hello, you're watching Lawline. I'm Alan Schnorman. We're at the Court of Appeals in Albany. We're speaking with Chief Judge Saul Wackler. Judge, right before the break, I had asked you, what effect does the public mood, the sentiment, have on the decisions of the court?
Well, it's an interesting question, and one that perhaps is not readily accepted by the public, but we have always preached that a judge should render his or her rulings free from the passions of the moment and free from the passions of the crowd. And that's very, very important. Elected officials in the legislative branch or the governor or president, depending on the governmental unit you're talking about, in the executive branch, should be very responsive to the majority will. And if he or she is not, then they'll be thrown out of office. But the courts cannot be responsive to the majority will. The court is there to respect the rights of an individual. And if the courts caved into the majority will at all the time, then there'd be persecution, rampant persecution. Because the majority might think that it's outrageous that that person says these things. Shut them up. It's up to the court to say, no, there's a right of free speech. Or someone might say, that religion is an abomination. He or she should not be able to practice that religion. It's up to the court to say, I don't care if the majority feels that that's a bad religion. We have a constitutional protection, and that person can worship as that person pleases. Now, if a legislator says that in certain instances, that legislator might be thrown out of office, but not a judge. So that it's very important for a judge, again, to rule on the law dispassionately and not to cater to the whims of the majority.
There was one recent article that stated that the Supreme Court in Washington is becoming more conservative. And as that court becomes more conservative, the state courts are becoming more liberal. Can you comment on that?
Well, it's not really more liberal, more concerned with individual rights and the rights of that individual to assert his or her personal choice, or the rights of that person to be freer from search and seizures and so forth. And one of the reasons for that is that, and this is something not generally known, we are not bound by the United States Supreme Court when it comes to enhancing the rights of our citizens. The Supreme Court sets the floor. We must certainly afford as much rights to our citizens as the Supreme Court says we must afford. But if we want to give greater rights to the citizens in our state, then the Supreme Court can't overrule us if we decided on our state constitution. For example, we decided that school teachers could not be subject to urine testing.
For drugs?
For drugs. Unless there's reasonable suspicion to believe that that teacher is using drugs. Now, if the United States Supreme Court tomorrow says that teachers can be tested, they might be able to be tested in other states, but not in New York State, because we have already ruled on our state constitution In other words, we have to go uphill with the United States Supreme Court, but we don't have to go downhill with them.
Judge, the abortion issue, much in the news. Now, if the Supreme Court in Washington outlaws abortions, can the court here in the state of New York rule any differently?
It could be. I'm not saying it would be, but if Roe v. Wade, for example, was overturned, so that
in Washington.
Yes, so that the freedom of choice of a woman was not considered a constitutional right in Washington. We don't have to follow that in New York State. We could still adhere to the Roe v. Wade ruling and say, no, perhaps the woman doesn't have that right in any other state, but in New York State, she might still have that right. And that's not generally known. People think that if Roe v. Wade is overturned in Washington, that's the end of abortion rights, for example, throughout the United States. Not true. Each state court applying its constitution can still adhere to the ruling by saying that that woman still has that right of choice. And that would then become the law in that state.
Getting back to the actual mechanics on appeals and in this courtroom, do attorneys argue? Can they argue as long as they want? Can the judges ask whatever questions they want?
The judges can ask whatever questions they want. The lawyers cannot argue as long as they want. We have time limits which are set up before argument begins. And 1 minute before that time limit is up, a white light goes on at the podium. And then after the minute passes, the red light goes on. When the red light goes on, the lawyer sits down. The lawyer can be interrupted at any time, and often is, and then respectfully responds to the question of the court. Because the court is trying, number one, to ask those questions relating to that aspect of the case which concerns the judge, and sometimes in anticipation of what will be raised at conference the next day when the judges are all together, a judge might ask a question of a lawyer to allow that lawyer an opportunity to answer and thereby become almost part vicariously of the deliberative process the next day. So that when the conference is held the next day, the judge can say, well, you remember I asked that question, you remember his answer, you remember her answer, so that that way it helps us reach a decision.
How important is this oral argument that the attorneys make? I mean, you have the briefs in front of you.
We've had the briefs in front of us. We've read the briefs. We've discussed the case with our law clerks. We've discussed it with our own internal deliberation process. But the oral argument can sometimes give us insights which escaped us. Or while we're reading the briefs, we might say, well, I don't understand this. Why do they say this case is distinguished? He doesn't really draw the distinction. We ask the question from the bench, how do you distinguish this case from People versus Smith? And the lawyer, in the pitch of oral advocacy, could answer the question very neatly and very concisely and very satisfactorily and resolve the doubt. So oral argument by a good oral advocate is extremely important.
Judge, where do you think the court is going in the next 10 years?
Well, I think the court will continue to be a good court because I think that every judge on our court will be here in 10 years from now. And I think that the people in the state of New York can rest assured that they have a court of last resort which will be functioning well and appropriately.
Judge Saul-Walker, thank you very much for inviting us up here to Albany and to be in your home.
It's my great pleasure and privilege to have you here.
We'll be right back after this short break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
My father, Gordon McCrae, was one of the biggest stars in musicals. He was also an alcoholic. When I was little, I thought I could stop my dad from drinking. But only the alcoholic can do that. And finally, my father got help and stayed sober the last 7 years of his life. I was so proud of him. Alcoholism is treatable and preventable. Be alert to signs that you might need help, especially if you're the child of an alcoholic. For information, call the National Council on Alcoholism, 1-800-NCA-CALL.
Talking computers, high-speed Braille printers, new technology helping blind and visually impaired people participate fully in today's computer age.
Gather moving the top of page.
For more information about putting high technology to work for blind people, write American Foundation for the Blind, National Technology Center, Box 111, New York, New York, 10011. The American Foundation for the Blind.
The 6 associate judges of the Court of Appeals were all appointed by Governor Cuomo. Yet they do not fall into any one category. They belong to 3 political parties: Democratic, Republican, and Independent. They're not considered liberal or conservative, but have aptly been described as pragmatic, cordial, and intelligent. One of the things that really impressed me is the mutual respect the judges have for one another.
It's a very close bonding relationship that you have with the other judges. It's someone has described it as like being married. You work together and live together, and you argue about common problems that implicate your views and beliefs very deeply. And as might be expected, it sometimes produces satisfaction of achieving something together, sometimes produces the antagonism of disagreeing with someone who can't see the worth of your views. But it's a very rewarding, enjoyable experience.
The feeling that we have for each other, the closeness we have for each other, is very important to the work that we do here. You know, the 2 weeks we spend here 10 times a year are really, we're in a little enclave ourselves, very much together, very much involved in the work of the court. And I guess for that period you could think of it as a family, a very odd kind of family, don't you think?
The fun is the interrelationship with my colleagues, interrelationship with my clerks and with the law clerks of the other judges. There's a collegiality and a congeniality to the court, which does make it very pleasant, a lot of fun. You're together trying to do a good job, but you're enjoying each other. You're enjoying trying to arrive at intelligent, wise, good decisions in a collective process.
The 7 judges are very close. It's an extremely, they use the term collegial. It's a group of people, like a committee, that gets along together very well, even though they have a lot of differences. On personality things, they don't have differences. On legal matters, they do have differences. And it's the same way throughout the court. I have very good relationship with people that I really don't contact every day for very long periods of time. But everyone is helpful. It's like a family.
What's it like being a judge on the state's highest court?
It's like having a good time under very difficult circumstances. The job is challenging, intellectually stimulating, rewarding, and very, very, very demanding in terms of your time, the exercise of your intellect, the arriving at a certainty that which you are deciding is a correct decision that conforms to the jurisprudence of the state on a stare decisis basis, deals adequately with the issues before you, and advances the common law in the particular area of concern.
It's a great experience if you're a lawyer, you know. You're here and you're making the laws really for the state under our common law process. So it's really an adventure every day, every case you have, you know. We are a cert court, which means we only bring up cases which we believe are of statewide importance.
What is it like to try to convince a fellow judge to your point of view?
You argue very vigorously all the time, and I've learned so much. You asked about the changes over time in my years here. I have learned a great deal about the meaning of collegiality, which is, it's a very fine art. I have read a lot about collegiality. I've never seen it well defined. It knows when to stand very firm as a matter of principle and when to stand less firm. We have to live from one case to the next, from one day to the next. It's not a battle to the death on every case.
We're supposed to be a reasoning, rational body, and the intelligence of your views, the soundness of your views is supposed to persuade other people that there is some flaw in theirs. I wouldn't guarantee that sometimes we don't resort to a little loud voices, but we try not to. We try to keep it on an intellectual level.
From time to time, the differences are not only marked, but they're argued strongly on each side. once in a while a voice is raised, but it's never personal. And sometimes the arguments get heated, but never is there any animosity which lingers, because you're differing over a question of law, or perhaps a question of policy.
I recently read an article that the New York State Court of Appeals has been setting the trend for the state courts throughout the country. How do you feel about that?
I feel wonderful about it because that's in the tradition of the great Cardozo bench, this is, and of the premier common law court, which is a reputation that it has enjoyed not only with Cardozo but with Fuld and Breitel. And that is an important role that New York plays with the other jurisdictions. I get to see it with respect to my American Bar Association section on legal education accreditation business, because I'm in contact with judges and legal educators throughout the country. So they're confirming and ratifying that to me, not because I read it in a newspaper, that that's so. They look to the beacon light in the development of the law to the New York Court of Appeals. That produces a lot of pride, not just because you happen to be a member of that bench, but for New York, for the reputation of this court.
I hope it does, and I think we're proud of that. It is probably one of the leading courts in the nation. We've always had a good court, and I think we do set a trend. I think other courts look to us for what we're doing.
We are but one of among many state courts that are turning more and more to the dual federalism concept that we speak of.
We have a lot of attorneys in our audience. What's your advice to them if they come before the Court of Appeals?
It may sound like the old professor in me and be very prosaic, but the two things that they have to do is be extraordinarily well prepared in knowing their record and in knowing the authorities that they have cited to the court. And the second thing is they've got to try out their case with their colleagues and peers before they come before what's called a hot bench and subject themselves alone at that lectern to the 7 machine gun firing questions of our court.
We are a hot court in that respect. We've read all the briefs, we've read all the cases, and we go into that courtroom with ideas of what questions we want answered. So they have to be prepared to answer any question and all questions with regard to that case and any cases pertaining to that case.
When he gets in front of us to argue orally, we'd like to have an overview, something that's condensed, something that hones in onto the essential points that are going to be dispositive. In most lawsuits, there are 1 or 2 questions that the decision is going to ultimately turn on if they can be identified and answered.
7 years ago, this court decided in matter of Storer and rejected the substituted judgment doctrine in favor of a rule that individual self-determination must decide questions of when and under what circumstances medical treatment will be withdrawn or withheld from incompetent patients.
Let's argue that this is not substituted judgment. This is merely using the judgment which she exercised when she was competent enough to exercise judgment.
Your Honor, the key to this case is basically specificity. That there was nothing, no one could interpret, first of all, what she meant, because no one knew what she meant. She never really explained what she meant by artificial life support.
Didn't she say that if she couldn't take care of herself, now what is the inability to feed herself, to reach from her hand from her plate to her mouth, or to put anything in her own mouth? If I can't take care of myself, now what standard? It's exactly like the modality, I agree. What standard must the layman be held to before they can say that they want to go out in dignity? Do they have to be terminal? Do I have to be terminal to refuse penicillin?
Are there any particular decisions that you participated in that stand out in your mind?
Oh, I can think of many. Well, for example, the right of an elderly, incompetent woman, terminally ill, to have artificial life support measures discontinued. That was a matter of O'Connor.
The recent one was Braschi, of course, where I said that a functional family could be other than 2 married people. and their natural children. Of course, that got nationwide and, in fact, international coverage because it dealt with two gay men, you know, and I guess it was the first time that gay people hadn't been bashed in a courtroom.
No, I just fortify myself against that, because my attitude about these cases and the people whose conflicts come here is that they have to be equal before this court, and you cannot treat any as, because either of the publicity that attaches or anything else, as more important, predominating. Because what that does is it subordinates a lot of others, and you then get the attitude that there are routine or more mundane matters. There are no routine or mundane things here, because every one of them is a case involving real people in conflict drawn into a court, and for them, it's the most important thing in their lives. I try to keep that going that way, no matter, I think a particular opinion is great, whether it's mine or somebody else's. I try to keep that, you know, on an equal keel.
We read one published article that stated that as the United States Supreme Court in Washington becomes more conservative, the state's highest courts are becoming more liberal. How do you feel about that?
That's interesting. I have taken a particular interest, as you may know, in the subject of state constitutional law. I have written several pieces on the subject. I would say that state courts have become more independent, and state constitutional law is one example of how they have become more independent. They have begun to think more in terms of their own constitutions, of defining the rights of individuals in terms of state constitutions, which is exactly as it should be, as if you think about it. And thinking less in terms of being reactive or just adopting what the Supreme Court of the United States does. So I would characterize it more as a feeling of independence, of doing the right thing for the citizens of this state, rather than being liberal or conservative or some sort of label.
What is happening is that state courts are more and more looking to their state constitutions as the predicate for determining issues involving the liberties and rights of the members, the citizens of their particular states. Now, very often the state constitution affords an adequate and independent state basis for the resolution of the issue, so that we can interpret our Constitution, for example, in a way that is consistent with our view of the common law and constitutional law of the state of New York. That is certainly accords no lower degree of privileges than does the federal Constitution, but frequently it gives greater protection.
Judge Kaye, what is it like being the first woman appointed as an associate judge on the court?
I have a mixed emotion about that. On the one hand, I regret that others have not preceded me, because it certainly was a long overdue appointment of a woman to this bench. I am delighted to be a woman on this bench at last, and I guess I would have to say, in a sense, it does enhance the pleasure. I focus, however, more on the fact that I am here rather than on all of the components that bring me here. It is all told a spectacular treat to be on this court.
Judge Alexander, what is it like being appointed the first black on the New York Court of Appeals?
In terms of my approach to my work, I suppose I do bring to this my whole background, as any person would. To the extent that my presence serves as a symbol to the black community at large and to the majority community, to tend to dispel in that area some of the myths that blacks, by virtue of their race, lack competence or whatnot, then my presence here belies that myth, to the extent that it demonstrates to young black youths that achievement is within our grasp. It serves as symbolically.
I know you and Judge Wackler have toured the dinner circuit together, giving speeches for each other and giving awards to each other. Give me a comment on that and your relationship.
Well, we're very, very good friends, but we're very respectful adversaries once in a while in the business of the cases. And on the bench itself, one incident comes to mind right after I was appointed. A young lawyer was arguing, holding on to the lectern, and I started to ask a question figuratively, which I will never frame in this way again. And all the other judges had been asking questions, and I said, "Counselor, what I'd like you to do is step back," meaning intellectually. And as I paused, the lawyer let go and started retreating 3 or 4 steps. And the chief judge said, no matter what Judge Bellicosa says, the oral argument's not over, you still have time. So needless to say, everyone erupted in laughter, and I laughed with red all over my face. And I said, let me reframe my question. That kind of thing, spontaneous humor, in the high, deep, serious business that we are about, is very human, very refreshing, and very good for all of us. And I think good for the lawyers, because they sense it's not something that's planned. What we do is, because of that, when we sense something like that happening in our real work, we try to retain it and then share it in some of these occasions when we're with the bar. That's what you've heard and seen from so many from many lawyers when we're out on the so-called professional circuit.
I'd like to give special thanks to the Chief Judge and the Associate Judges of the Court of Appeals for graciously giving of their time and taking us into their courtroom. And as always, this is Alan Schnorman, and I'd like to thank you for watching Lawline.